Yeah, hello. Good afternoon, ladies and gentlemen. I am Noel Hebron-Logan, a final honors 2 student of Private College, reading law. And my responsibility this afternoon is to crave the indulgence by helping out fellow students that are at the verge of enrolling into the LLB program. I would like to give a tutorial in regards of contract law, to which I will specify myself on specific topics in contract law, which is one of the major holdings of contract law itself, which is known as privity of contract. Well, on the ambit of privity of contracts, it cannot be overemphasized based on the fact that it has immensely contributed to meeting the expectations of what contract law itself is, and it has been known, well recognized by every little ambit of contract. Now, privity of contract under this notion is a common law doctrine, which says that only those that are privy or party to a contract can sue on a specific contract. In common trend, it is a common law principle which says there is no way a third party can sue on a contract where that party is not a member or is not privy at the material time that contract was entered into. So, in this regard, this doctrine came about to actually quash the ideology which to us as law students would deem it necessary as very barbaric, as it has been known as a common law principle. As we all know, common law has been very harsh to the law, which actually injected sanity by bringing to the fore what we call equity, which later quashed the harshness of what common law is. So, therefore, this doctrine of privity says that nobody can sue on a contract where that individual is not party to that contract, or is not informed, or has not consented, has not actually given consideration in that contract. Only those that have given consideration, as we all know, contract is polarized along what we known as consideration for a contract itself to be recognized as a contract. So a third party cannot sue on this because he hasn't or she hasn't given any consideration. But only those that have given consideration can sue on this doctrine of privity. This was first tested in a locus classicus case of what we call Tweedle and Atkinson. In the case of Tweedle and Atkinson, this was a kind of contract that was entered into by the parents of the bride and the groom. The parents, meaning the fathers, came together to put measures in place to enforce or to finance the wedding ceremony of their children, that is the bride and the groom. And later, the father of the woman died. The father of the bride died, and the groom decides to sue the executor of the bride's father's properties, meaning when the father of the bride died, there was an appointed executor. So this was at the time the groom now decided to sue the executor of the bride's father, which was known as Twiddle, John Twiddle. When they sue to enforce this contract, it was proven in that case that the groom hasn't given any consideration. It was only the fathers that actually went into the contract to give consideration, not on the part of the groom. If the groom would have given consideration, then it was only at that backdrop he would have succeeded in his claim. So at the end of the day, he failed because of lack of consideration. Later, it was also tested in a case known as Dunlop Tires versus Selfridge. It has now become a well-recognized, case where privity of contract was finally handed down in that case, known as Dunlop Tires versus Selfridge. Now, the fact of that case. This was a case where Dunlop, as a manufacturer of tires, went into a contract with an agent or a third party known as due. So at the material time they entered into such a contract, it was stated in their bargaining that the third party known as due should not sell the said products of tires to any third party at a rate that is not recognized by the manufacturing industry known as Dunlop. So Due now sold this tire to Selfridge, and Selfridge sold at a price that was not acceptable by the factory, meaning Dunlop. So Dunlop now brought an action against Selfridge. So when they went to court, it was finally decided in that case that privity of contracts may be recognized in a situation where a third party cannot sue on a contract where he hasn't given any consideration. So Dunlop failed in his challenge against Selfridge because of privity of contract. Now, this had become a locus classicus of law, where privity of contract was recognized and it became well celebrated all over the world. So therefore, in a case where privity is recognized, the individual must have given consideration before that individual can sue on the said contract. But without a valid consideration, that contract cannot hold as a result of lack of privity. That has been the locus establishment of the law. But however, we all know that to every general principle, there is an exception to the law. These are areas every lawyer in the world may intend to hold, where a co-counsel might have held an opinion of establishing privity by saying that a third party cannot sue on a contract. But for a competent lawyer, a good lawyer who have actually done his research, may hold on the exceptional aspect of the law. As we know, to every general law, there is an exception. So the exceptions will be as follows. Even though we might have a lot of exceptions to privity, but for the purpose of this lecture, I would like to demystify by limiting myself on few areas of those exceptions. So to start with, I would like to start with what we called trust. Well, when we talk about trust, it is a situation where a set law delegates a responsibility to what we call a trustee, or by giving a property to a trustee to hold on trust for the benefit of the beneficiary. So in a trust relationship, three people are important. That has to do with the set law, the trustee, and the beneficiary. The beneficiary is recognized in any trust relationship based on the fact that a trust is established for someone who is known as a beneficiary to enforce that trust. Where there isn't any beneficiary, that trust is not recognized. So, as I was saying, for a trust to hold, there must be, it's a must, it's incumbent by law that there should be a beneficiary that is known as the third person in a trust relationship, which now become an exception to the general rule, where a third party who was not privy to the material to the contract at the material time the contract was entered into by the settlor and that of the trustee, but he as the beneficiary can enforce that trust even where he wasn't a member or he wasn't privy to the contract at the material time the two people entered into that contract. So this trust in a relationship like that, the object, which is known as a beneficiary, can now enforce a trust. As we can see that for it to be established by law, a trust relationship can only be guaranteed where there is a beneficiary, as it was later established under the beneficiary principle in a case known as Morris versus Bishop of Durham, which made it bears that a beneficiary should be established in every trust relationship for it to become valid. As we know, for a trust, we have certainties to be known by law, which makes it very valid by law. And for it not to result, or for it not to become a resulting trust, by coming back to the trust, to the settlor's estate, meaning if the trust is established without a beneficiary to enforce that trust, it may become a resulting trust by coming back to the settlor's estate, meaning the person that has actually set up the trust. So that was why the beneficiary principle under the object aspect of the certainties, as we know, we have three certainties: certainties of intention, certainties of subject matter, certainties of object, which is the beneficiary. So that is why Bishop Morris versus Bishop of Durham established that principle for an enforceability, that a trust can only be considered as a trust where there is already somebody there to enforce, which is known as the beneficiary. So that beneficiary is a third party. So a third party who hasn't been privy to a contract can now sue or enforce that contract where the trustee might have failed to follow the dictates of the settlor. The second part of the law, which is an exception to the general principle of privity, is what we call agency. Of course, when we talk about agency, agency has become one of the bases of contract law, one of the sweetest aspects of the law. As we know, when we talk about agency, it is a relationship where a principal delegates a responsibility to his agent to act on his behalf, and the act of that agent is as well the act of that principal, as per the legal maxim which says, qui facit per alium facit per se. He who does by others does by himself. So meaning, if a principal does an act by his agent or through his agent, the act or conduct of that agent is presumed by law that it is the responsibility or the act of the said principal who has dedicated a responsibility to his agent. So even in a situation where that agent goes into a contract with a third party, and where there had been a default on the part of that agent, it will as well be the responsibility of the principal. So the third party who have actually gone into contract with the agents has the power, has the right by law to sue the principal direct. So, as we have seen, we have what we call the principal, we have what we call the agent, we have what we call the third party. So the third party can now bring an action against the principal, even where the third party haven't been privy, or the agent, or the principal haven't been privy to the contract between the agent and the third party. But the third party can still bring an action against the principal for delegating a responsibility into his agent. By a default, it is still the responsibility of the principal who have delegated the responsibility on his agent to act on his behalf, from the legal maxim qui facit per alium facit per se. He who does by another does by himself. But however, on the ambit of agency, it is as well important for fellow students who are at the verge of pursuing the LLB program, or who are at the verge of becoming a very good lawyer in the future, should have it at the back of their mind that a provision was created under the agency relationship by a legal maxim which says delegatus non potest delegari, meaning a delegated authority cannot be delegated. If a principal delegates a responsibility to his agent to act on his behalf, that said agent cannot delegate that responsibility to another. It will become a breach of an agency relationship. So the agent there might be liable for a breach of that agency relationship. He has no power to delegate the power that has already been delegated to him by law. Meanwhile, with this, even where the agent goes into a contract with the third party can bring an action against the agent for a breach of the said contract. It is still the responsibility of that principal. The principal has the power by law to pay damages to the third party and sue the agent, or bring a legal action against the agents for causing damage to his agency relationship. The third one I would like to treat here has to do with indemnity and guarantee, which I will consider to be one of the exceptions of the general principle of what we call privity of contract. Indemnity and guarantee. When we talk about indemnity and guarantee by law, it is a relationship that is established by law where somebody can take up responsibility on behalf of another. Now let me put it in the local context, or in simple context for fellow students to read and understand, or to listen and understand from my tutorial. Now when we talk about indemnity, if I am to pay you money, which is $100,000, and I failed to pay that money, then somebody who is my friend decides to come to say, okay, Mr. Kuruma, I know Mr. Logan is supposed to pay you $100,000, but don't ask Mr. Logan anymore for that money. I will pay you. That has actually skipped the responsibility from Mr. Logan to Mr. Kuruma by the law of indemnity, meaning Mr. Logan, who has been the primary obligor, has now skipped his responsibility through the intervention of Mr. Kuruma, and Mr. Kuruma has now become the primary obligor in this case. But initially, Mr. Kuruma was the secondary obligor, whilst Mr. Logan was the primary obligor. But upon taking the responsibility on behalf of Mr. Logan, automatically by law, Mr. Kuruma has become the primary obligor, while Mr. Logan is now the secondary obligor. So if Mr. Logan has nothing to do in this situation. You now come as the creditor, you now come after the third party who has indemnified on behalf of Mr. Logan as per law of indemnity. So the creditor can sue the third party where the third party must have breached underpayment as per indemnity. So which has now become an exception to the general rule of privity. We saw it in the case of Dunlop and Selfridge in this situation. So the creditor in this situation can now bring an action against the third party who has indemnified a debt on behalf of Mr. Logan. Automatically, he has become a primary obligor, while Mr. Logan is now the secondary obligor. And now, under guarantee, it doesn't mean when the individual says that he will pay, has actually skipped responsibility. He is only serving here as a guarantor. He is still a secondary obligor, but the responsibility still show that on the creditor, on the debtor, who is Mr. Logan, who is supposed to pay the creditor the $100,000. So the creditor can come after the debtor, who is Mr. Logan, to pay him his money. Yeah, the credit and the third party here is just guaranteeing the payment that okay, if Mr. Logan hasn't paid the money, I will make sure that he pays the money. I will make sure that that money will be received by you. So the statement there hasn't indemnified. It is a guarantor. He is guaranteeing the payment that Mr. Logan will pay in the situation. So in a nutshell, I actually do not want to go much into this. I would like to stop there for now, as I know a third party can bring an action in a situation where that third party hasn't become member or party to a contract at the material time that contract was entered into, which makes it an exception to the general rule of privity, which says only those that are privy or member or party to a contract has the power to sue on the contract and succeed. But the exception here, a third party can still sue on a contract where he wasn't privy to the contract at the material time that contract was entered into. So the aspect of creating an exception to the general rule of privity tells all and sundry that indeed equity is a unifier, is a transformer to the harshness of the common law in privity and contract. So therefore, I would like all colleagues out there who may be fortunate to watch this video, which is just a short video I have actually made to help fellow students to learn from the basic principles I have established, which makes it simpler for them to listen, read, and understand from this short skit I have produced. So therefore, I want to say thanks to listeners and viewers of this video as you await other videos to keep coming up in contract law, criminal law, equity and trust, land law, to name but a few, will be part of my tutorial, which may become beneficial to fellow students. I thank you all for your audience.